started with two guys and two girls who played instruments in the school band. They started hanging out and writing their own music. At first, they sounded a little rough, but with some practice and a lot of hard work, they started to find their way as musicians. They worked on lyrics and developed their songwriting style. Eventually, they attracted a following of devoted fans. One day, a talent scout came to a show, and he liked what he heard. He asked the group if they had copyrights for their songs, and they said,
"Copyright? What's a copyright?"
That's what we're about to find out. Hi everyone, I'm Karina Gates. Welcome to the Business Basics series. Today, we're going to explore the world of copyrights. Anyone who creates original works can obtain a copyright. According to the U.S. Copyright Office, a copyright is a form of protection provided by the laws of the United States to the authors of original works of authorship including literary, dramatic, musical, artistic, and other intellectual works. What kind of protection does a copyright provide? If you own the copyright, you have the exclusive right to publish, reproduce, and sell your work. The term exclusive means just you. If someone else wants to use, reproduce, sell, or perform your creative work, they must get your permission. Without it, they are breaking the law, and you can take them to court. So, what do we mean by creative works? If you write a book, an article, or a screenplay, you can copyright it. You can copyright a movie or a play. If you write the software and design the animations, you can copyright a computer game. You can copyright dance choreography. You can also copyright a work of art, like a painting, a sculpture. And of course, if you write a song or any other piece of music, you can copyright it. It's important to remember there are some things you cannot copyright. Here's a rule of thumb. You cannot copyright an idea, but you can copyright the expression of an idea. Whoa, that sounds complicated. Let's break it down. Say you discover a unique mathematical theory. The theory itself cannot be copyrighted. It's an idea or a concept. If it were copyrighted, then no one would be able to think about it without breaking the law. That would be hard to enforce. But what if you write a book to share your theory with others? Well, that's different. You can get a copyright for the book that you write. Basically, in order to copyright something, you must have a physical copy of it. The music, the dance routine, or the play cannot be copyrighted unless there is some record of its existence. The music needs to be recorded. The steps to the dance choreography must be mapped out, or at least the performance must be videotaped. The same goes for any kind of performance, like a comedy routine. You have to get your work on paper or on a tape or CD. What about works that contain basic information, like a calendar or a tape measure? Well, you have to ask yourself, what is original about these things? This information itself is not original. Calendars and measurements are general knowledge. But the design of the calendar, the pictures or artwork you choose, the colors and the style of print are all products of your creativity. So, you could copyright the design of a calendar, but that doesn't prevent others from designing different calendars with the same general information. Let's go back to the band. They've chosen a name, the Unknowns, and they want to protect it so that another band doesn't use the same name. However, they can't copyright it. The U.S. Copyright Office doesn't register names or titles or slogans. That's the job of the U.S. Patent and Trademark Office. To protect a name, you must register the name with the Trademark Office. When you submit a registration application, the trademark officials search their files to ensure the name is not already registered by someone else. If the Unknowns come up with a distinctive way to show their name in print, or a design or symbol for the band, that's a trademark too, not the copyright. The Unknowns can trademark their name and a logo like this one, and they can copyright their songs. Speaking of the songs, the band has to determine who gets credit for them. Mick lays down the tunes, while Crystal writes the lyrics. Jay and Sally, the other band members, don't write the songs, but they do play instruments when they record the music. So, who has the rights to the music? Well, it depends on what rights we're talking about. The two composers can get copyrights for their songs in written form, and the whole band can get copyrights for the recording itself. So, you can see, copyright law can get confusing. When a group of people create something together, it's best to get the specifics ironed out ahead of time. Here's another situation. Let's say the unknowns want to record a song that someone else wrote for them. Even though the songwriter isn't recording the song, as the creator, he still owns the rights. The exception to that rule happens with an employer-employee relationship. If a television studio hires a scriptwriter to work on a comedy show, the scripts that writer creates are the property of the studio. Of course, as a legal protection, the studio would typically have the writer sign a contract. Collaborative projects can create disputes, so it's important to seek the advice of an attorney who understands copyright law. Now, did you know that you may already be the owner of a copyright? That's right, and you didn't even know it. If you have written a story, or painted a picture, or recorded an original song, you own the copyright to that creative work. Amazing, huh? The U.S. Copyright Office doesn't require you to file any forms or register for a copyright. The law says the minute you finish a painting, write something that is original, or record music, you own a copyright. So, why do people go to the trouble of applying to the U.S. Copyright Office? Well, for protection. Although you know you created your work, it's awfully hard to prove without a registered copyright. If someone uses your work without your permission, they are committing infringement. You can take that person to court, but your work must have a registered copyright, or the court may not be able to distinguish who the true owner is. Having a copyright can actually prevent the hassle of a lawsuit. Nobody wants to spend their time and money protecting what is already theirs. That's an even better reason for copyrighting your work. Registering your work with the Copyright Office is one way of letting the public know it's yours. Copyrights don't actually prevent anyone from using your material, but they do discourage people from breaking the law. It's a good idea to let other people know you have a copyright as well. Once you have a copyright, you can print a reference to it on the work itself. Suppose your name is Maria Smith, and you wrote a play and copyrighted it in the year 2000. The best way to let the world know you have a U.S. copyright is to print Copyright 2000 Maria Smith right on the work. The little C with a circle around it is the standard symbol for a copyright. Take a look at any book or magazine. Copyright information is usually printed on the back of the title page in a book and on the publication information page in a magazine. CD covers generally have the letter P with a circle around it instead of a C. The Copyright Office uses the P to indicate it's a phonorecord, which is a formal way of saying any recorded format: tape, record, or compact disc. These symbols are followed by the name of the copyright holder. If someone wants to use the copyrighted material for profitable means, they must contact the copyright holder and get permission from them for a particular use. If someone profits from the use of copyrighted material, the copyright holder is entitled to compensation from the person who profited. So, you see, it's important to get your work copyrighted. You never know, someday it may make you some money. Getting a registered copyright is easy. All you have to do is fill out a form from the Copyright Office and enclose 2 copies of your creative work. Mail the package to the Library of Congress, the home of the Copyright Office. Copyright inspectors will determine if your work is copyrightable. As we have mentioned, the material must be original, tangible, which means in some physical form that is readable or can be viewed or listened to, and it must fall within one of the copyrightable categories. Again, those categories are literary works, software, musical scores, dramatic performances, choreography, pictorial, graphic, and sculptural material, motion pictures and other audiovisuals, sound recordings, and architectural material created after November 30th, 1990. If your work meets these three requirements, you'll get an official copyright certificate in the mail. Now that you have an official copyright certificate, how long will it last? The answer is a long, long, long time. Copyrights protect creative material for the life of the author plus 70 years. That's plenty of time for creative people to enjoy the fruits of their labors. After the copyright expires, the creative work becomes available for use by anyone free of charge. This is called public domain.
Old MacDonald had a farm,
E-I-E-I-O,
and on his farm he had a dog.
E-I-E-I-O.
Are the unknowns violating anybody's copyright by singing Old MacDonald Had a Farm? No. Lots of old folk songs are considered to be in the public domain. They've been around so long that any copyright is now expired. Anyone can record the music without having to gain permission or pay royalties. If they make a recording, their performance will be under copyright. But the song in general will still be in the public domain. One song the band can't record is Happy Birthday to You. It's under copyright. People sing it in their homes all the time. But if you sing it in public or for a profit, then you're violating the copyright. There are ways to use copyrighted material without committing copyright infringement. Fair use is a term that describes the various legal uses of copyrighted material. There are exceptions to the rule. Under the fair use rule, a teacher can use an artist's copyrighted material as part of what he or she shows the students in class. Teachers can play a song, print copies of an article, or act out scenes from a play without violating copyright law. News reporters also get a fair use break, as do movie critics. As far as the copyright law is concerned, it's fair use for them to use movies, articles, and other information for journalistic purposes. Now, teachers and journalists can use copyrighted material to teach and report, but they must be careful to give credit to the author or creator. If they don't, they could be accused of plagiarism. Plagiarism is different than infringement. While infringement is the unauthorized use of copyrighted material, plagiarism is claiming to be the author of someone else's creative work. Plagiarism is a very serious offense, but it is easy to accidentally plagiarize, especially when we write papers in school. You must always be careful to give credit to all of your sources when you are researching and using other people's words. Be careful when you paraphrase as well. Derivative works, which means any work that is derived from the original, are also covered by copyright. So even if you reword a quote by a famous author, you must give that author credit. The last means of fair use is the parody. A parody is a comical distortion of an original work. You may see TV actors replaying a scene from a famous movie, only they are exaggerating some element of the scene. The exaggeration is what makes it a parody. Some musicians have recorded their own versions of a song, in a sense, making fun of the original work. Although some attempts to parody original work are disputed, most of them fall under the parody rule of the Fair Use Clause. Courts encourage artists to come up with brand new ideas, as well as new twists on existing ideas. The U.S. Supreme Court decided that a parody song was more of a fair use than an infringement. However, fair use is an area of copyright law that is always evolving, which is one of the things that make copyright so fascinating. So, before you go out and create the next big symphony, write the great American novel, or paint a portrait of a friend, make sure you learn all about copyrights. It's your right. Thanks for joining me today. Bye.
View all 12 titles in the Business Basics series.
The ups and downs of stocks.
The profits and pitfalls of mutual funds.
Supply and demand.
The profit and loss statement.
The accounting equation.
Careful with credit.
Advertising tactics.
What's next?
Patents.
Copyrights.
Business writing.
Don't look at your hands. An introduction to keyboarding.